This two-part presentation is going to go into depth about the 1 to 4 family residential contract. Right. 1 to 4 family contract is only to be used for residential property, okay, of 1 to 4 units. So if it's a duplex, it's fine. Same thing with triplex or quadplex properties. Do not use it for a never occupied property. You'd use a new home contract or a commercial property. They have commercial contracts, obviously, or land only, which would be unimproved property contract. So if a residential property has barns, pens, cross fencing, etc., then use the farm and ranch contract. And of course, this is not for use of condominiums. They have another property form for that. Now, prior to using this form, it would be prudent to check the county records to determine the owner of record. If later found incorrect, other party can change after submitting an offer. Okay, so you could use an amendment if it wasn't the correct names for the seller. Paragraph 1, do not put TBD or owner of record, which I've seen, okay, in the seller's name area. That does not comprise a legal contract. Right? You need to have a seller's name and a buyer's name in paragraph 1. Now, it could be a company name or an estate name or an individual name. So if husband and wife, it could be either or both. The term property comprises 3 elements, okay? The land, improvements to the property, and accessories of the property. Paragraph 2A defines the legal description of the property and should be taken from the county records. Don't just arbitrarily put in the address in there and leave all the other pertinent information from the county out, which is lot, block, the name of the subdivision, the city that it's in, and the county that it's in. All right, and then you would put the address. So some rural properties may have very little information on the county record. Okay, paragraph 2B defines the part of the property titled improvements. There's a lot of discussion and arguments over what is or are improvements and what stays with the property, what does not. So read this carefully and understand it. There's been many other webinars and discussions from Allegiance Title, etc., and Texas Realtors that will help you understand what includes improvements. Now, even the paragraph itself is kind of vague. If you look at some of the things, it talks about try and define cleaning equipment. Okay, what are they talking about? The operative words are permanently attached or installed. So, is a hanging mirror permanently installed? Probably not. I've seen arguments over mirrors being taken by the seller that were hanging mirrors. If they're permanently installed and attached to a wall, it's a different story. So make sure the buyer has a very clear understanding of what conveys with the property. Arguments such as flower pots on the patio come up all the time. Oh, gee, I saw all these flowers outside and now they're gone. Okay, well, you know, that was not part of improvements. So the Texas Realtor has a definition of what are improvements, and it would be wise to read that link. Again, another one of the vague items that are in improvements, it says outdoor cooking equipment. Well, what does that mean? Does that mean a barbecue? Does it mean a built-in barbecue? Probably a built-in, but not a Weber that's on wheels. So anything that is attached and semi-permanent or permanent could be considered an improvement. Paragraph 2C, again, also causes confusion, but if read carefully, it's pretty much self-explanatory. The main conflict regarding this paragraph are window coverings. Seller usually believe that because they spent thousands of dollars on drapes, they're going to take those with them when they leave. Again, be specific in asking what is staying and what is being left behind. You'll save yourself a lot of anxiety later on when the buyer and the seller start fighting about what they thought was going to stay or what was not. And you're going to be caught in the middle. One of the smart things to do is when you represent the seller and you have a listing agreement, go over this part of the contract with them so that they understand what is supposed to be left with the property, and it also will help them make any exclusions. So don't wait until you have an offer and then it becomes a conflict because there's a disagreement as to what stays and what does not. Do it upfront when you have a listing agreement, and also make sure that you check MLS to see what has been excluded, if anything, from the sale of the property. Paragraph 2D, if they did not put any exclusions in there, it's assumed that these items are going to stay with the property. Paragraph 2E talks about mineral interests that are passed over to the buyer or retained by the seller. Those are handled via an addendum, which is TAR 1905. So it's just a kind of a notice that's saying part of the property, okay, may include gas, oil, or mineral interests, and those will be handled by an addendum. Paragraph 3, pretty self-explanatory, talks about how much a person is going to put down, a cash portion. It's also how much is going to be financed and what the total sale price, or in the case of a buyer, an offer price, until it gets signed. The cash portion, remember, is independent of the earnest money. It has nothing to do with the earnest money. So fill this out completely, and if financing is a part of the contract, make sure a box in 3B is checked. Paragraph 4 talks about any relationship that may exist between agents and buyer or seller. So the items that you would put in there would be buyer's agent is related to buyer, seller is a licensed Texas realtor, something along that line. So read that paragraph. All right, it requires a license holder who is party to a transaction or acting on behalf of someone. Then the license holder has to identify themselves, okay, that they are part of the deal. So read the paragraph closely, understand what the requirements for notice are. Paragraph 5 talks about earnest money. All right. Let's identify that earnest money is not a necessary part of a contract offer. You could put 0. Okay. Earnest money is not required to make a contract. Typically, what's done in there is about 1% of the offer price. Okay. The second sentence in that paragraph allows the buyer to deliver additional earnest money within a certain stated amount of days. The second sentence is very rarely used because most agents don't understand how it can be used to their benefit. Okay, you could use this as a delay of supplying the earnest money. Let's say if you had a contingency deal. So if you were doing a backup contract, okay, or if you had, say, sale of other property addendum, you could stipulate in paragraph, the second sentence of that paragraph, that you would provide the earnest money within X number of days after the effective date of this contract. So it's a way of not putting up the earnest money until you're sure you're part of the deal. And also, the benefit to that is there would be no fighting over earnest money, if the backup contract fell through or the sale of other property. We know that a lot of times sellers are reluctant to sign a release of earnest money for whatever reason, even inappropriately. So this would be one way of helping to protect the buyer's earnest money. So the buyer has 3 business days to deliver the earnest money to the escrow agent identified above. If they do not deliver it, the seller may terminate the contract by giving notice to buyer before they deliver the earnest money. Okay? Time is of the essence. That means that there is no grace period. If you do not meet the time frame, you are in default. There's no wiggle room. Okay, paragraph 6 talks about the title policy and the survey. Now, the title policy really is nothing more than an insurance policy against claims against the property so that the buyer is protected under title. Now, I'll give you an example of how that comes into play in a moment. So typically the seller pays for the owner's policy of title, but it's negotiable. It could be either or, buyer or seller. Now, one of the things that's confusing is that that title policy has certain exceptions to it, and it lists those exceptions down number 1 through 8. Okay, those things are not what's covered in the title policy. Those are exceptions to the insurance. The number 8 will be discussed in the next slide. It can be confusing. The language on Schedule B of a title commitment states that the title insurer is not liable for discrepancies in boundary lines, encroachments, etc. that would be shown on a survey of the property. Right. With the satisfactory survey reviewed and approved by the title company, the buyer may choose to remove the area and boundary exception, which adds additional coverage into the title policy. Okay, 6A8II. At last look, the cost of the additional coverage is 5% of the cost of the title policy to get that additional coverage for any encroachments or discrepancies in boundaries. Okay, here are some examples of what would be covered if you chose that additional insurance. Say a utility company required removal of improvements that are located in an easement that were there obviously beforehand. Well, that would be covered. Buyers use a pre-existing survey prepared for a previous owner. In many cases, the surveyor is only liable to the homeowner who purchased the survey. So any discrepancies with the survey would also be covered in that instance. Or the HOA claims that improvements are built over a building line and demand improvements be removed. A neighbor claims insured improvements are over the property line into their property. So anything that might pop up that turned out to be a surprise with regards to encroachments or boundary lines is what's going to be covered. Now, I mentioned earlier about telling you an instance that I came across where about a year after closing on a property, I had a buyer client call me and say, "Lou, I just got a notice of foreclosure on my property." I said, "Well, are you current on your loan?" He said, "Yeah, that's not an issue." Well, it turns out that during the title search, the title company missed a second lien. Apparently, they didn't find any record of a second lien. Well, time went by, and guess what? The second lien holder filed foreclosure proceedings against the property. And we got in touch with the title company. We got the foreclosure stopped first, and then got in touch with the title company. And because they were liable, and it was a title policy which covers those things, the title company had to pay $11,000 to pay off that second note. So it was their responsibility, their error. So that's one of the ways that title policy protects you. All right. Paragraph 6B informs the parties that the seller has an obligation to ensure that the title company provides the buyer with a commitment for title. So it's kind of incumbent on the seller to make sure that, and the seller's agent to make sure that that is delivered to the buyer. This informs the buyer that the property is title insurable. This has nothing to do with who pays for the title policy. Okay. So if the buyer does not receive the documents in the proper time frame, they may terminate and receive the earnest money back. Now, there's a nice video about title commitment from Allegiance Title. I put the link on there. Take a look at it. It's very informative. Okay, paragraph 6C identifies who's responsible for providing a survey to the buyer. Make sure one of the boxes are checked unless the buyer does not require a survey. Could be a cash deal. Nobody wants to pay for the survey because a lender's not going to require it. Okay. Item number 1 requires the seller to provide a survey to the title company along with a T47 affidavit for approval by the title company within the stated days. Right? Understand that if this box is checked, the seller cannot say they can't find their survey, or they lost it, or the dog ate their homework. They must provide one, or the buyer will obtain or can obtain a new survey at the seller's expense. So if you read that paragraph, it says that if seller fails to furnish the existing survey or affidavit, then the buyer shall obtain a new survey at their expense no later than 3 days prior to the closing date. Okay, and then it goes on to say, if the existing survey is not acceptable to the title company, one of the two parties has to pay for a new survey. Check the appropriate box. So again, everything's negotiable. Typically, if the survey, then it would probably be a buyer's expense. The seller has done relatively, justice by putting forth a survey in a T47. He could have done that based on what he knew at the time. So, but everything's negotiable. Either seller or buyer would pay for a new one. Items 2 and 3 simply state who is going to provide and pay for a survey. Okay, either the buyer is going to buy one or the seller is going to buy one. Okay. Paragraph D gives a buyer room to object if the title company or exceptions or survey show defects or encumbrances other than what was listed in 6A. This is pretty difficult to comprehend considering the all-encompassing list of exceptions already talked about in those documents. One example that comes to mind is the buyer putting in language that says ability to put an in-ground pool, right, in that blank line up there. If no deed restriction prevails, this could be a valid objection, right? So, buyer buys a property, he wants to raise pigs, right? He'd put something like that and say, okay, I want to have a pig farm. Well, it would be incumbent on the title company to find out what would be allowed, okay, or at least get the documentation from deed restrictions or other information that would inform the buyer what he could not do in terms of having pigs or an in-ground pool. Okay. Now, if it comes out that he can't do that, the seller can cure the objection within 15 days. If do not, buyer can deliver a notice of termination, or buyer can waive the objection. All right. So again, provided seller is not obligated to incur an expense, all right, they can cure timely objections, but it's highly unlikely that if something that's in there, the seller is going to be able to correct, but it's possible. Paragraph E1 advises buyer to have a title search by an attorney or title company. This protects buyer from any surprises as to ownership, liens, etc. Well, we've already talked about that. If you're going to use a title company, this is what they do. They're going to give you an abstract of title. It's a warning to buyer that don't leave a title company out of the equation. All right. Paragraph E2 talks about membership in an HOA. Okay, paragraph E1 is warning buyers to use a title company, to have an abstracted title, either through an attorney or a title company, to protect themselves. If you don't, let's say it was just a deal between buyer and seller, they didn't use a title company, they didn't want any third parties involved, well, you would proceed at your own risk, because you wouldn't know whether the person that was selling you the property had clear title. That's what a title company or a lawyer's title will provide. E2 indicates that the property is or is not in an HOA. And remember, there may be more than one HOA for a particular property. Like Stonebridge Ranch, there are some little areas that not only have the Stonebridge Ranch HOA, but they have their own little mini HOA, of which you'd have to be adjoined for both. So in that case, most people don't realize you'd actually have two HOA forms attached to a contract. Now, one of the things that this paragraph tells you is that you're entitled as an owner to receive any and all copies of, the subdivision laws, rules and regulations, etc. Now, if you're not sure whether the property has an HOA, there's a couple of ways that you can check. All right, you obviously ask the seller's agent. It could be indicated on the MLS, or it could be on the seller's disclosure. If you're not sure, make sure you inquire. Because one of the things that in order to, if it's found out that there is an HOA, you're going to have to get a resale certificate, which basically the HOA is saying to the title company, they don't owe us any money or fees, etc. It is clear to go. You can, proceed with the sale. Now, one of the reasons that you have that HOA addendum, all right, is to memorialize the fact that the buyer is going to get all these documents and have an opportunity to review them, and also an opportunity to cancel if he doesn't like anything that's in the restrictions or the rules and regulations of the HOA. It also tells you whether the HOA has any lawsuits against it, any hidden fees, that type of thing. So it's a wealth of information, most of it which will make the buyer's head spin, but it's important that they have that. Okay, again, it informs the buyer that there is an HOA, they are obligated to join. There's records, CCRs, covenants, conditions, and restrictions. Informs them that they're required to pay any fees. They're entitled to their documents as mentioned, and a resale certificate will be given to release the property to the title company. Now, E3, it's not common, but it could arise. Best way to check is the county record for the property. When you look at the county records, if you're not familiar with them, they usually have like 3 items. They have the school, all right, like say McKinney ISD, then they have the city of McKinney, and then they have the county. And those are the 3 taxes that you usually pay. Well, there could be a 4th one hidden in there. It could be some kind of a bond issue. It could be an extra tax to provide some kind of service. They may be building a stadium. They could be building some, utility facility. Okay, so that's what statutory E3 statutory tax district talks about. That if you are in one of those situations where there is a statutory tax district, all right, the seller is required to deliver, and you're required to sign, okay, a notice relating to the tax rate, bonded indebtedness, or standby fee of the district prior to the final execution of this contract. Now, in all my years, I have not seen this provided to anybody. Now, maybe because there's very few statutory tax districts in our area, but I hope and presume that the title company would provide that, or at least raise a red flag if there was one. Okay. There's an example here that if a developer gets approval to form a water district and sells bonds to raise money to construct that water treatment plant or for water storage, all right, they would have an extra tax tacked on there. It's probably an interim, 5 years, 10 years, something like that. So the tax rate would be modeled upon the notion that once all the homes were constructed in that development and all the lots had the appraised value, it would be great enough to cover the debt service on those bonds. So just keep an eye on the county records to make sure there's nothing other than the 3 normal taxation rates. Okay. E4 does not come into play in our area, but unless you're purchasing shorefront property or something that has a title effect, which is going to be very difficult in Collin County. Annexation, E5 notifies the buyer that the property may now or later be included in an ETJ, and that's an extraterritorial jurisdiction, and may now or later be subject to annexation by a municipality. Extraterritorial jurisdiction, as it refers to cities, is the legal capability of a municipality to exercise authority beyond the boundaries of its incorporated area. In the U.S., Texas is one of the states that by law allows cities to claim ETJ to contiguous land beyond their city limits. For instance, if you look at a Farmersville map, Farmersville currently has an ETJ. The city has the right to annex that and pull it into the proper incorporation of the city. ETJ has a tax benefit in the sense that they don't have to pay any city taxes or on the property tax. That's why a lot of people will complain if the city's trying to annex an ETJ. They know that they're going to get hit with extra taxes, and sometimes they balk about doing that. But there is benefits, because then you get, the city benefits of police, fire protection, all that comes with being part of the city. All right, so this notice is given so that buyers are aware that if the property is in an ETJ, the city might incorporate it, most likely leading to higher property taxes. E6 notifies the buyer that the property may be located in a certificated water or sewer service area. Very rarely applicable in a developed area, but it could be possible. The county property records, again, will shed some light on this, okay? If you would like to see what areas fall under this category, go to this link for a map of these areas, but the normal areas that we do business in, it does not apply. But if you're not sure, check on it. Item number 7. To form a public improvement district, more than 50% of the property owners must sign a petition, though some cities, including Dallas, require a higher threshold. Once the district is approved, the City Council approves a work plan and sets an assessment rate each year. Property owners would pay an annual assessment, usually based on the property value, similar to taxes. In essence, it's an additional property tax. Okay, so if the county or local government decides they want to do something special, they may tack on, an additional assessment onto the property. But again, it's got to be voted on first. So usually if the property is in a public improvement district, it would be reflected in the county tax record. Consider it a special improvement to the area. Number 8, transfer fees. Okay. It's a percentage of a property's sale price, typically 1%, that is remitted to a property's original developer each time it sells. This was one of the greatest scams ever perpetrated on the buying public. And the selling public, I might add. Okay, and this came directly from the crazies in California, all right, where a developer wanted to recoup some of his money and tacked on, or was able to tack on, a fee or a percentage of the sale price every time the property sold. Okay, so in recent years, regulatory changes have made these fees less common. In fact, as of September 2014, 43 states, including Texas, prohibit private transfer fees in most situations, according to the NRA. Now, a title company can determine if this applies because they not only disallowed them, all right, in Texas, but in many cases they could not be renewed. They were only available, I think, for 3 to 5 years, and they were not allowed to be renewed. So highly unlikely you're going to see transfer fees. One of the most misunderstood paragraphs, a propane gas system service area. I see the addendum in contracts many times, okay? But understand there are only 72 areas in Texas where this applies. Most of them are in Travis County, okay? And there's a link below it that'll tell you which ones those are. Yet agents sometimes include TREC Form 47-0 on a contract, which does nothing more than confuse a buyer and or seller. Don't confuse the fact that a rural property that uses a propane tank for heating, gas, etc. falls into this category. This is much greater than that. This is where you have piped in gas from a service provider owned by a distribution system retailer, not a county. Okay, so take a look at the link. It'll clarify if this ever comes into play. Highly unlikely. Okay, notice of water level fluctuations. Yet another notice that seller must warn buyer about. Okay, and that's why it's in there. This is the warning. All right, this would apply if there was a pond or a lake on the property and it was subject to fluctuations. Look at this as a beware of flooding warning. No form applies here. This is the warning in its entirety. So what they're telling people is that, hey, if there's a storage capacity of at least 5,000 acre feet on the property, you better be careful, because if the rains come or there's no flow through or anything like that, you could wind up having flooding on the property, all right, or drought, either one. Okay, so that's what the warning is. It's there. You don't have to do anything. All right, that's the end of part one. Part two will be coming shortly.